think for a moment. How many contracts do you think you've entered into? Well, just today.
Probably quite a few, right?
Exactly. From your morning coffee, maybe your Netflix subscription, these everyday things are quietly powered by this legal framework.
Mm-hmm.
So today on the deep dive, we're aiming to give you a shortcut to being well-informed about these essential legal agreements.
Yeah, exploring what contracts actually are, why they're so crucial.
And how they shape, well, everything. Personal exchanges, global commerce.
We want to give you those aha moments.
Definitely. We'll dive into real-world examples, look at the core ingredients of a binding agreement, and even peek into how contract law adapts, globally.
It really is a journey into the hidden architecture of daily life. It's fascinating how they provide stability, often without us even realizing we're interacting with the law.
Absolutely. So let's kick things off by highlighting just how pervasive contracts are.
Yeah.
Many of us, I think, picture a contract as some thick, jargon-filled document you sign in a lawyer's office.
Right. Very formal.
But the reality is far, far more expansive. That coffee you bought, your bus ticket, clicking play on a streaming service.
All contracts.
Yeah.
Simple ones, but still contracts.
And then slightly larger things, maybe buying a new fridge or hiring a plumber.
Still contracts.
Yeah.
Just involving more value, perhaps more terms.
If we connect this to the bigger picture, then, these contracts are the essential legal infrastructure for any planned transaction.
Pretty much, yeah. They don't just regulate the exchange itself. They define duties and, crucially, outline consequences if someone doesn't fulfill their part.
Okay, the consequences bit is key.
It is. That's how societies and economies allow people to plan ahead, relying on others to meet their side of the bargain. Without that reliance, well, commerce as we know it just wouldn't function.
So it's definitely not just big corporations we're talking about. Businesses of all sizes rely on these constantly.
Precisely. You've got commercial agreements to build houses, highly specialized contracts for servicing jet engines, or even just leasing some office space.
All commercial contracts.
Exactly. And this really challenges that perception you mentioned earlier that contracts have to be in writing.
Right, the formal document idea.
Yeah, many are actually quite informal. They can be formed through phone calls, conversations, even just emails back and forth.
So a verbal agreement can be binding.
Often, yes. Now, a written agreement offers crucial certainty and evidence, and we'll see why that matters with the Blue v. Ashley case later.
Okay.
But most contracts don't actually require that formality. Although it's important to remember there are specific exceptions.
Like what?
Well, the big one is contracts for the sale of land. Those absolutely must be in writing. No exceptions there.
Got it. It really makes you wonder, if you're listening right now, how many contracts you might have entered into just in the last week.
Easily dozens, maybe more, without thinking about it.
It's also striking, something mentioned in the sources, that where contracts are written, especially, say, consumer ones, there's often an imbalance of power, isn't there?
Yeah.
Limiting our ability to actually influence the terms.
That imbalance is a huge factor. And it's precisely why we often distinguish between consumer and commercial contracts.
Okay, so B2C versus B2B.
Exactly. A consumer contract, B2C, business to consumer, that's when an individual, like you or me, buys something for personal use. Getting a new phone for yourself, for example.
Right.
A business contract, B2B, business to business, that's for goods or services related to a company's trade or profession. Think of a restaurant buying its food supplies.
And the rules are different.
Significantly different, yes. Consumers typically receive much more legal protection because of that potential power imbalance we talked about.
Okay, that makes sense. So if these agreements are everywhere and they're not always formal or written down, what exactly is a contract from a legal perspective? It feels like something so fundamental should have, a clear definition.
You'd think so, wouldn't you? But what's actually fascinating is that English law, surprisingly, doesn't have a single formal definition of a contract.
Really? How does that work?
Well, it's not seen as a weakness. It's actually often viewed as a testament to its flexibility. It allows the law to evolve alongside society and the economy.
So it adapts.
Precisely. Legal scholars, they all tend to point towards the idea of a legally binding promise, or maybe an agreement creating obligations enforced by law.
Okay.
But the fact we don't have one rigid definition, as some academics like McKendrick point out, isn't really a flaw. It's arguably the source of English contract law's adaptability. It helps it navigate everything from, ancient trade disputes to today's digital marketplaces.
That adaptability makes a lot of sense, especially with how fast things change. But you mentioned agreement is central. Are there, complexities to that simple idea.
Oh, absolutely. While agreement is definitely the bedrock, we need to add some crucial layers. For instance, courts actually look at the objective appearance of events.
Objective appearance, what does that mean?
It means they're looking at how a reasonable person would interpret the situation, not necessarily what someone was subjectively thinking inside their own head.
Ah, okay, so not about feelings, but about actions and words.
Exactly. And not even necessarily whether the deal seemed fair in hindsight. Also, even if there is an agreement, parties are expected to act according to certain standards of behavior. Sometimes the courts impose these.
Standards of behavior like good faith.
Sort of, yeah. Things like that. And finally, that idea of freedom of contract isn't absolute anymore. Judges and Parliament, too, have stepped in over the years to protect weaker parties. That's a big shift we should definitely get into later.
Okay, so the courts are looking at what appears to be agreed, plus certain standards, and acknowledging that pure freedom isn't the whole story. Even without a single formal definition, you mentioned there are foundational elements that must be present for a contract to be legally enforceable.
Yes, that's right. Despite the lack of one definition, there are 4 well-established key elements the courts look for.
Okay, what are they?
First, you need agreement,
Right, the core idea.
which itself needs a clear offer made by one party and an unconditional acceptance by the other. No changes to the offer in the acceptance.
Got it. Offer, acceptance, what's next?
Second, consideration.
Consideration.
Yeah, it means an exchange of something of value between the parties. Each side has to give something or promise something.
Okay, so it can't be a one-sided promise usually.
Generally not no. Third, there must be an intention to create legal relations.
Ah, this sounds important.
It is. The parties must genuinely intend for their agreement to be legally binding, not just a casual chat or a social arrangement.
Okay. And the last one.
Finally, capacity. This means the parties must be legally capable of entering a contract. So generally, adults of sound mind, children, for example, usually can't enter into binding contracts, with some exceptions.
So agreement, consideration, intention, capacity, if any one of those is missing.
The whole thing could potentially fall apart, legally speaking. No enforceable contract.
Right. Let's zoom in a bit on that offer and exceptions part, because that seems fundamental to establishing the agreement itself.
Absolutely crucial. Let's take Elodie from our scenario later. If she goes into the Run for Fun shop and offers $55 for a pair of trainers.
Okay, that's the offer.
Right. And if the shop assistant says, okay, $55 it is, that's the unconditional acceptance, boom, you have a contract. Simple exchange.
Makes sense. But what if the shop says something different?
Ah, good question. If Run for Fun responds, sorry, we can't do $55, but we'll sell them for $65.
That's not accepting her offer.
Exactly. That's not an acceptance at all. Legally, it's a counteroffer.
A counteroffer?
Yes.
Yeah.
And importantly, a counteroffer does 2 things. It rejects Elodie's original offer of $55, so that's gone, and it creates a new offer, the trainers, for $65, which Elodie can now accept or reject.
So the original deal is off the table completely.
Completely off the table. No contract is formed on those original $55 terms.
That distinction is really crucial. What about when you just see goods displayed in a shop? Like you mentioned those 150 pairs of trainers at Run for Fun. Is the shop offering them to everyone walking by?
That's a great question, and it catches a lot of people out. It's another critical distinction in contract law.
Okay.
Displaying goods in a shop or on a website or even in an advert is typically not considered a legal offer.
It's not. What is it then?
It's what lawyers call an invitation to treat.
Invitation to treat. Sounds a bit formal.
It does, but the idea is simple. It means the shop is inviting you, the customer, to come forward and make an offer to buy the item.
Ah, so I make the offer when I take the trainers to the till.
Precisely. The shop isn't offering those 150 pairs to Elodie specifically. They're inviting her to make an offer for the pair she chooses at the price displayed.
And the shop can then accept or reject my offer.
Exactly. This protects the shop. Imagine if displaying goods was an offer, they might be legally bound to sell more items than they actually have in stock if loads of people tried to accept it once.
Right, that makes practical sense. Okay, going back to those 4 elements, that idea of intention to create legal relations feels quite subtle, but you said it's vital.
Incredibly subtle, and yes, absolutely vital. Without it, even if you have what looks like a clear offer and acceptance and even consideration, the whole thing can fall apart.
And the Blue v. Ashley case is a prime example of this.
It's a fantastic, very vivid illustration, yes.
Yes.
It was a 2017 high court case. It involved a business consultant, Jeffrey Blue, suing the well-known entrepreneur Michael Ashley, the founder of Sports Direct.
Okay, what was the claim?
Blue claimed that Ashley had promised him a huge bonus, £15 million. Apparently, if Blue could somehow ensure Sports Direct's share price rose above £8 per share.
15 million. Wow. And where was this offer supposedly made?
This is the crucial part. It allegedly happened during a night of heavy drinking in a pub with several other people present. Lots of pints involved.
In a pub. Okay, I can see where this might be going.
Right. Eventually, the share price did actually go above £8, but Ashley refused to pay the £15 million. So, Blue sued him.
And what did the court decide? I mean, enforcing an agreement made over many pints in a pub sounds tricky.
You're right to think that. The judge, Mr. Justice Leggett, dismissed Blue's claim entirely. He found there was no legally binding contract.
Why not? There was an alleged promise, wasn't there?
There was an alleged promise, yes. But the judge focused heavily on that objective test we mentioned earlier. How would a reasonable person, observing this whole interaction, interpret what was said?
And the context mattered hugely.
Hugely. Leggett J. pointed to several key things. First, the sheer extravagance of the statement itself, £15 million, an enormous sum, especially linked to something Blue couldn't directly control, like the overall share price.
Okay, seemed unrealistic.
Second, the setting. An evening of heavy drinking in a pub, he said, was just completely the wrong context for serious formal contract negotiations. It wasn't a boardroom meeting. Third, he doubted Blue actually had the power to single-handedly cause such a huge jump in the share price anyway. And finally, he noted, it just seemed out of character for Ashley to make such a serious, binding promise in that kind of jocular pub atmosphere.
So even if Ashley said the words, the court looked at the whole picture and decided a reasonable person wouldn't have taken it as a serious, legally binding offer.
Exactly that. The judge essentially concluded that Ashley's statement in that specific context was mere banter or pub talk.
Just banter.
Right. And therefore, it couldn't form the basis of a legally binding agreement because that essential element, the intention to create legal relations, was objectively missing.
Wow. That case really does vividly illustrate that point. Not every promise, no matter how grand it sounds, actually creates a contract. Context is everything.
It's a powerful reminder, absolutely. The courts aren't just looking at the words spoken in isolation, they're looking at the entire situation.
That Blue v. Ashley case, it really highlights how dynamic contract law is, and it definitely hints at deeper principles. Let's maybe delve into how English contract law actually developed and some of those underlying philosophies you mentioned.
Sounds good. English contract law is a cornerstone of what we call common law.
Common law, right, meaning it comes from judges' decisions mostly.
Primarily, yes. Its rules have mainly developed over centuries through judicial decisions and custom, rather than being laid down in one big piece of legislation like a civil code you might find in other countries. Historically, judges were the main architects, making rules in specific cases.
Which then set precedents for future cases.
Exactly. That framework provides certainty and predictability for people entering into agreements.
And I've often heard the term freedom of contract linked with this common law tradition. What does that really mean?
Freedom of contract was a really central idea, especially back in the 19th and early 20th centuries. The basic philosophy was that courts should be very reluctant to interfere with agreements people made. The belief was that parties should be entirely free to decide their own obligations, set their own terms.
So the court just enforces whatever was agreed?
Largely, yes. The legal maxim, caveat emptor, let the buyer beware, was very influential back then.
Let the buyer beware.
Yeah. The judge's role wasn't really seen as rewriting the deal to make it fair. It was simply to enforce the bargain the parties had struck themselves, even if one side ended up with what seemed like a really bad bargain.
But surely that pure freedom sometimes led to, well, unfairness, especially with those long, complicated agreements, the small print.
Absolutely. That classical approach was certainly intensified by the rise of standard form contracts.
Standard form, like the ones you get with your phone or insurance?
Exactly those. Often presented on a take-it-or-leave-it basis, you don't really get to negotiate.
Yeah, a negotiation, yeah.
And they tend to be drafted by the more powerful party, representing their interests. They often include pages of small print with terms that can be quite onerous, quite tough on the other side.
Putting less powerful or maybe less informed people at a big disadvantage.
A significant disadvantage, yes. However, things did start to change. Attitudes began to shift, particularly from the mid-20th century onwards.
How so?
Judicial thinking evolved. Judges started to place more weight on the context of a bargain, thinking more about principles like fairness, good faith, reasonableness, and social justice.
So a move away from purely enforcing the letter of the agreement.
A definite move. It led to greater legal protections for weaker parties in contracts through both case law and legislation passed by Parliament. This ongoing tension, this kind of push and pull between strictly enforcing the agreed terms versus ensuring a degree of fairness, that's a really critical aspect of modern contract law.
It sounds like a constant balancing act. And of course, contract law isn't just static or stuck within national borders, is it? Our world is so interconnected now.
You're absolutely right. It's a dynamic field, constantly influenced by global factors.
How has globalization and maybe evolving societal values shaped English contract law?
Well, historically, international trade itself significantly shaped English law from the beginning. Many early rules came from the customs of merchants trading across borders.
Okay, so it always had an international dimension.
It did. And as our understanding of fairness and basic human rights evolves, so does the law defining what can even be contracted for. It's a stark and frankly uncomfortable reminder that not so long ago contracts could legally involve people as property.
A truly dark part of history.
Indeed. Thankfully, that's now rightly abolished by laws like the Slave Trade Act 1824 and, much more recently, the Modern Slavery Act 2015. This isn't just a historical point. It shows how profoundly core societal values can reshape even fundamental legal principles, drawing clear lines around what's permissible in an agreement today.
That's a really powerful point about law reflecting or maybe catching up with human values. Beyond that fundamental level, have there been efforts to make everyday cross-border contracting easier, more standardized?
Oh yes, definitely. Lots of efforts. These are all about trying to build bridges between different legal systems to simplify international trade and allow businesses to contract globally with, a bit more certainty.
Sort of like creating a common language for contracts?
That's a good way to put it. Even if not every country adopts every single standard. For instance, there's the Vienna Convention on Contracts for the International Sale of Goods, this CISG. It's a treaty setting out standard rules.
Is the UK part of that?
Actually, no, the UK hasn't ratified the CISG, which is interesting in itself. But then you have non-binding frameworks, like the Unidroit Principles of International Commercial Contracts, or PICC.
Non-binding. So how do they work?
Parties can choose to agree that their international contract will be governed by these principles. They offer a neutral, internationally recognized set of rules.
Okay, so it's optional.
Right. And similarly, within Europe, there were initiatives like the Principles of European Contract Law, PETLL, aiming for a more unified approach, though things had obviously changed there too. All these projects, they're constantly pushing contract law to adapt to things like our borderless economy, the challenges of electronic contracting. It just shows how vital and evolving this area is for businesses and for our everyday lives.
It really is constantly adapting. Okay, let's try and bring all this legal theory back down to earth now with a final practical exercise. Let's see how many contracts and maybe potential problems we can spot in a typical day using that scenario about two people, Elodie and Charlotte.
Great idea. This is where contract law really comes alive, seeing it in action.
So thinking about their day.
Okay, well, Elodie has a stall at the local farmer's market. Selling goods involves multiple contracts. Charlotte books flight tickets online, clear contract there. Renewing her phone contract, another one.
The daily milk delivery.
Yep, contract for regular supply. Elodie applies for a credit card that's an application leading to a contract. Her buying new trainers for her son, Ben.
We used that example earlier.
Exactly. A family booking a holiday cottage in Scotland. Andre's school fees being paid. Hiring a new employee, even on a 0 hours contract.
0 hours contracts themselves are complex legally.
Very much so. Even using volunteers might involve agreements about expenses or responsibilities. Hiring a landscape gardener to build a soft play area for the kids.
That sounds like a bigger project.
Definitely a more detailed contract needed there. Charlotte signing up for a new streaming service, probably clicking, I agree, to lengthy terms.
We all do that. And ordering takeaway pizzas.
Yep, another everyday contract for goods and services, see? They're absolutely everywhere.
Wow, it really is constant. And where might the potential problems, the disputes, creep into these everyday agreements?
Well, in that same scenario, problems could easily pop up. Maybe the milk delivery is the wrong quantity one morning.
Annoying, but a breach of contract.
Potentially, yes. A breach of the agreed quantity. Ben's new trainers could develop a fault after just 5 weeks, raising questions about consumer rights, quality, remedies.
Right, the goods have to be satisfactory quality.
Exactly. Charlotte might use some photos she found online for a project without agreeing to pay the photographer that could lead to intellectual property issues and contractual ones if terms were breached.
Okay.
What else?
Maybe the email about Andre's school fees is ambiguous about payment dates, causing a dispute. Issues could arise with that 0 hours contract, or if the new employee asks for cash payments outside the agreed system.
Tricky areas.
Definitely. Elodie might notice the landscape gardener made a mistake in building the soft play area. Or the terms of that streaming service free trial might be deliberately unclear about when charges start.
That old trick.
Happens all the time. Or maybe your internet goes down, affecting services you've paid for another potential breach of contract by the provider.
So many potential pitfalls. It just reinforces that contract law isn't just dry theory. It's a really practical, pragmatic subject. It comes alive when you apply it to real life. And hopefully, understanding these basics empowers you, the listener, to navigate your own daily transactions a bit more confidently.
Absolutely. We've journeyed through this surprisingly complex landscape of contracts today. We've looked at what they are, explored those essential elements.
Agreement, consideration, intention, capacity.
Right. We've witnessed their evolution from that strict freedom of contract idea towards a greater consideration of fairness.
And touched on their crucial global reach and adaptation.
Hopefully you listening now have a clearer lens to view your own daily interactions, realizing you're an active participant in this vast web of legal agreements, often without a second thought.
You really are entering contracts constantly.
So here's a final thought to ponder. If contract law is designed, on the one hand, to create stability and facilitate exchange, but its history also shows how freedom of contract sometimes allowed for significant unfairness, how much should the law intervene today to ensure fairness in all agreements?
That's the million-dollar question, isn't it?
Especially as those lines between personal and commercial deals, formal and informal agreements, keep getting blurrier. How much intervention is the right amount? It's definitely something worth thinking about as you move through your own contractual deep dives.